Mr. Fishman, you're next.
Thank you. I am honored to have the opportunity to testify before you and the other members of the subcommittee today regarding the constitutional parameters of denaturalization. Over the past few months, 3 naturalized citizens have murdered or attempted to murder Americans in apparent terrorist attacks. It strains credibility to assert that when naturalized, they had met the requirement of being of good moral character, attached to the principles of the Constitution, and well disposed to the good order and happiness of the United States, or that they truthfully professed when taking the oath to support and defend the Constitution and renounce all allegiance and fidelity to nations of which they were once subjects. Why does it matter that they were naturalized? Naturalized citizens are not subject to deportation. They can serve in Congress, can vote in federal elections, and have an unfettered ability to work for the federal government. The Supreme Court has stated that citizenship obtained through naturalization is not second-class citizenship, but carries with it the privilege of full participation in the affairs of our society. Federal law provides that the government can seek to denaturalize those who illegally procure denaturalization or procured it by concealment of a material fact or by willful misrepresentation. The court has made clear that an applicant for naturalization must be in strict compliance with all the congressionally imposed prerequisites to the acquisition of citizenship, and failure to comply with any of these renders citizenship illegally procured. However, the court has also ruled that, at least under current law, the government must provide clear, unequivocal, and convincing evidence in a denaturalization proceeding. But the court has seemingly indicated that Congress could substitute a lower standard of proof. Can the government revoke naturalization based on behavior engaged in or beliefs expressed post-naturalization? As one federal court put it, post-naturalization evidence can at best rise only to the level of evidential facts, as to a citizen's state of mind at naturalization. While the Supreme Court has expressed dubiousness as to whether disqualifying views expressed after naturalization are accurate representations of a citizen's views when he took the oath, the court has not held that they are insufficient proof as a matter of law. In 1950, a special subcommittee of this committee explained that during World War II, the Supreme Court began to hold the government to such a strict standard of proof that it became very difficult to denaturalize citizens with Nazi sympathies. The subcommittee thus recommended enactment of a new federal law, providing that joining a subversive organization within 5 years after naturalization shall be presumptive but rebuttable evidence that naturalization was obtained unlawfully. But it emphasized that this is not intended to place a condition subsequent upon naturalization, but rather simply to create a rule of evidence. The recommendation was enacted into law in the Internal Security Act of 1950, and in modified form remains the law today. One difficulty in assessing the presumption's constitutionality is that it has rarely been invoked, and as far as I can tell, never been the subject of a federal court decision. But we can look for guidance at federal court decisions regarding other such presumptions. In 1913, the Supreme Court concluded that for a legislative presumption of one fact from evidence of another not to constitute a denial of due process of law or a denial of the equal protection of law, it is only essential that there shall be some rational connection between the fact proved and the ultimate fact presumed. The court concluded that the denaturalization presumption it was reviewing passed this test. It stated that Congress has indicated its opinion that the intervening period may be as much as 5 years without rendering the presumption baseless. It noted that that period seems long, but that we are not prepared to pronounce it certainly excessive or unreasonable. But the court cautioned that as the intervening time approaches 5 years, the presumption necessarily must weaken to such a degree as to require but slight countervailing evidence to overcome it. Conversely, when the intervening time is so short as it is shown to have been in the present case, the presumption cannot be regarded as yielding to anything short of a substantial and convincing explanation. Thank you.